Land reforms in the law in relation to ceiling on land holdings. Ceiling on agricultural land holdings. Discuss the concept, meaning, scope of expression ceiling on land holding in India. Concept, meaning of the expression ceiling on land holding. Concept of ceiling on land holding is one of the umbrella areas of land reforms, whether in India or elsewhere in the world. The expression ceiling, it denotes imposition of statutory limit on the holding of land by an individual owner and to surrender to the government the surplus land, which is in excess of the ceiling limit thus imposed. The expression holding means owning or keeping in hold of land by an individual. Thus, land ceiling or holding is a method which puts a ceiling limit on the extent of holding of land by an individual and forms part of the study of land reforms. This method requires the landholders to declare in the prescribed manner the extent of land held by them in excess of the ceiling limit and to surrender the excess land to the state or government. In countries like India, this step is taken up as a measure of reducing the economic inequalities among the citizens by fixing a statutory limit to the right to hold land to the extent of such limit and then to hand over the land declared to be in excess to the government for distribution among the landless poor or to use the same for any given public purpose. The government is empowered to take over and distribute such excess lands among the landless and needy people for any value or free of cost as the case may be. The sole objective of this law is to ensure equal distribution of the economic resources of the country among the citizens and to reduce the gap between the rich and the poor as directive principles of state policy. Scope of ceiling on land holdings in India. The above subject requires to be studied under two heads, namely land ceiling with regard to agricultural land and land ceiling with regard to urban land. Each one of these heads is discussed below in the context of land reforms in the states of Andhra Pradesh and Telangana. Land ceiling with regard to agricultural land. In the states of Andhra Pradesh, and the legislature has enacted the Andhra Pradesh Land Reform Ceiling Agricultural Holding Act 1973 so as to consolidate and amend the law relating to fixation of ceiling on agricultural holdings and take over surplus land and to provide for the matters connected therewith. It is coming to force with effect from 1175. This act has repealed the earlier act of 1961, which provided inter alia for the imposition of a ceiling on agricultural holdings, which in case of existing holdings ranges from 27 acres to 324 acres depending upon the class of land. This act has repealed the Andhra Pradesh Agricultural Land Prohibition of Alienation Act 1972. This act, which has been included as item 67 in the 9th schedule of the Constitution by 34th Amendment, is protected by Article 31A of the Constitution inasmuch as it constitutes an agrarian reform. This act is also aimed at achieving the uniform national policy for imposition of ceiling on agricultural holdings consequent upon the acceptance of the recommendation of the Central Land Reforms Committee. Land ceiling with regard to urban land. The Urban Land Ceiling Regulation Act was enacted in 1976. Over the years, the working of the act was found to be objective of enacting this law could not be achieved. Therefore, this act was repealed in 1999 by the Urban Land Ceiling Regulation Repeal Act. Notwithstanding this repeal, the act is still in force in many states, including the state of Andhra Pradesh, inasmuch as the law falls within the ambit of state subject. Discuss the salient features of the Andhra Pradesh Telangana Land Reform Ceiling on Agricultural Holding Act 1973. The law on the above subject in respect of states of Andhra Pradesh and Telangana is a derivative of the provisions contemplated under the then Andhra Pradesh Land Reform Ceiling of Agricultural Holding Act 1973 with effect from 2nd June 2014 and continue to be in force thereafter with a slight modification with the words Andhra Pradesh shall be replaced by Telangana insofar as it is applicable to the state of Telangana. The following are the salient features of the AP Telangana Land Reform Ceiling and Agricultural Holding Act 1973. The object of the Act is to consolidate and amend the law relating to fixation of ceiling on agricultural holdings and for taking over of the surplus lands, besides providing for the matters connected therewith as provided for in the preamble of the Act. The Act, consisting of 30 sections, has come into force with effect from date of notification, that is 1175, although the assent of the President was first published in 1173. The Act, under the Section 2, declares that it gives effect to the policy of state towards securing the principles specified in clauses B and C of Article 30 of the Constitution of India. Section 3 of the Act provides for definition of the terms under various provisions like appellate tribunal, bank, ceiling area, double crop wetland, dry land, family unit, government source of irrigation, holding, land, owner, person, revenue division officer, specified date, standard holding, tenant, tribunal, wetland. The Act puts a ceiling in case of a family unit consisting of not more than 5 members at an extent of land equal to 1 standard holding, as provided for in the Section 4 of the Act. Standard holding means the extent of land specified in Section 5 of the Act. In case of a family unit consisting of more than 5 members, the ceiling area is at an extent of land equal to 1 standard holding, plus an additional extent of 1/5 of 1 standard holding for every member in excess of the 5, subject to maximum extent of not exceeding 2 standard holdings. The Act provides provision for increasing limit of ceiling area where an individual or an individual member of a family unit has one or more major sons, holds no land or holds land less than the ceiling area as provided in Section 4A. Section 5 of the Act provides for standard holding for different classes of lands and the manner of computation of standard holdings as shown in the table given in that section. The Act empowers the government to constitute tribunals by notification specifying the jurisdiction of each such tribunal and other issues under Section 6. Act contains special provisions in respect of certain transfers made on after 24 January 1971, but before the notified date of any land by way of sale, gift, usufructuary mortgage, exchange, settlement, surrender, or any other manner, including creation of a trust of any land as provided under Section 7. The Act requires every person whose holding exceeds the specified limit to make a declaration of such holding as provided in Section 8. Act empowers the tribunal to determine ceiling area under Section 9. Section 10 of the Act requires a person whose holdings are in excess of the ceiling area to surrender such excess land. Act empowers the Revenue Division Officer as authorized officer to take over the land surrendered or is deemed to have been surrendered by the owner thereof as provided in Section 11. The possession of such land vests in such officer. Section 12 of the Act regulates the land involved in a mortgage with respect to surrender thereof. The Act provides special provisions for protected tenants where the holding of any owner includes land held by him as specified in Section 13. Act requires the lands vested in the government shall be allotted for use as house site for agricultural labourer, village artisan, other poor persons having no houses or house sites, or to transfer such land to the weaker section of the people depending on the agriculture for agricultural or ancillary purpose of agriculture as provided in Section 14. Section 15 of the Act requires payment of amount for any land vested in the government at rates specified in the second schedule either in cash or in bonds or partly in cash and bonds. Section 16 of the Act empowers the tribunal to determine the amount payable for the lands vested in the government. Section 17 of the Act prohibits alienation of a holding by an individual or an individual member of a family unit of excess land on 24 January 71 or any time thereafter by way of sale, lease, gift, exchange, settlement, surrender, usufructuary mortgage, otherwise or effect a partition thereof to create a trust or convert an agricultural land into a non-agricultural land until he furnishes the declaration under Section 8 along with the extent of land to be surrendered. Section 18 of the Act requires declaration for future acquisition of lands in any manner whatsoever, usufructuary mortgage or lease or any marriage or adoption or any alteration in the classification of the land, etc. Section 19 of the Act requires furnishing a declaration before registering officer at the time of registration of any document to the effect that holding of the transferor does not exceed the ceiling area. Section 20 of the Act makes provision for making an appeal before appellate tribunal constituted by the government against an order passed by the tribunal or RDO within 30 days from the date of communication of the order. Section 21 of the Act provides for revisioning powers on the High Court from any order passed by the appellate tribunal in respect of matters related to jurisdiction. Section 22 of the Act provides the powers of authorities under Act, namely appellate tribunal, RDO, any officer authorized by the above, and these authorities shall have the same powers of the civil court under CPC. Section 23 of the Act provides for exemption from the applicability of the Act to the lands held by the state or central government or any local authority or religious charitable education institution or a waqf of public nature. Section 24 of the Act provides for penalties for failure to furnish a declaration or for contravention of any provisions of the Act and rules made or order issued. The Act provides protection and civil criminal liabilities for the actions done in good faith under the Act against the officers or authorities and also against the government or any damage caused or likely to be caused as provided under Section 25. Section 26 of the Act bars jurisdiction of the civil courts in respect of any action taken by any officer or authority under the Act. Section 28 of the Act facilitates the provisions of the Act to override other laws. Section 27 of the Act empowers the government to make rules, and Section 29 of the Act empowers the government to remove difficulties arising in giving effect to the provisions of the Act. Section 30 of the Act contains provisions for repealing AP Sealing and Agricultural Holding Act and the AP Agricultural Land Prohibition of Alteration Act. The Act therefore enjoys the protection of Article 31A, C. Anil Kumar vs. Deputy Commissioner AIR 1959, Assam, and Sonapur Tea Company vs. Deputy Commissioner AIR 1962. The Act, which is included in Item 67 in 9th Schedule by Constitution 34th Amendment, is protected by Article 31A as it undoubtedly constitutes an agrarian reform. Once Article 31A is retracted, Article 14, 1931 go out of the picture. Define the term sealing area and explain its scope under AP Telangana Sealing Agricultural Land Holding Act. Definition of sealing area. Section 3C of the Act defines sealing area to mean the extent of land specified in Section 4 or 4A to be sealing area. Extent of sealing area. Section 4 of the Act provides for extent of sealing area in the following manner. In case of a family unit consisting of not more than 5 members in respect of which the sealing area is an extent of land equal to one standard holding as provided for in Section 4.1 of the Act. In case of a family unit consisting of more than 5 members, sealing area is an extent of land equal to one standard holding plus an additional 1/5 of one standard holding for every member in excess of 5. Subject to maximum extent not exceeding 2 standard holdings as provided under Section 4.2. In case of a family unit, the sealing area shall be applied to the aggregate of lands held by all the members of the family unit. Explanation below Section 4.3. And in case of an individual who is not a member of the family unit, in case of any other person, the sealing limit is an extent of land equal to one standard holding. Section 4.3. Increasing limit of sealing area. Section 4A of the Act provides provision for increasing limit of ceiling area where an individual member of a family unit having one or more major sons had no land or holds land less than the ceiling area. Section 4A of the Act reads as follows. Benefit of Section 4A is available only to persons who have major sons. As on the commencement of the Act, definition of the family unit. Notwithstanding anything contained in Section 4, where an individual who is a member of the family unit has one or more major sons or any such major son either by himself or together with other members of the family unit, of which he is a member, holds no land or holds an extent of less than the ceiling area, then the ceiling area in case of such individual or a family unit, of which the said individual is a member computed in accordance with Section 4 shall be increased in respect of each such major son by an extent of land equal to the ceiling area applicable to such major son or the family unit of which he is a member, and as the case may be, by the extent of land by which the land held by such major son or a family under which he is a member falls short of the ceiling area. Judicial trends or case law. Member of the family unit. Illegitimate Hindu major sons of Shudras and not of Brahmins are members of the family unit to determine ceiling area. Statement of objection and reasons for enacting Section 4A also shows Section 4A is introduced mainly with a view to relieve hardships caused to Muslims and Christians by not allowing separate unit in respect of a major son as in the case of persons governed by Hindu law. A. Veerraju versus State of AP. Procedure for determining holdings. Holdings have to be determined by clubbing joint family property and separate property. P. Koti Ramachandra Raju versus State of AP. Position of a major son in computing extent of land of ceiling area. In computing the extent of ceiling area of the father, the extent of land which falls short of the ceiling area to which the major son is entitled to under Section 4A has to be allowed. Tippa Reddy versus State Ramachandra Rao. For the purpose of the present Act, the concept of son, grandson under Hindu law cannot be pressed. Section 4A is intended to confer marginal benefit of giving advantage of the deficit area of the major son for the purpose of ceiling, and the inclusion of a grandson amounts to unduly stretching the Act. The concept of son inclusive of grandson under Hindu law cannot be pressed into service as this is a special enactment, and the reach of the provisions of the Act has to be construed in consonance with the intention and purpose of the Act and within contours of the provision. And Rangana and others versus State of AP. For applying Section 4A of the Act, it is the holding of family unit and not the share of individuals in the family is important. Once an individual is found to be a member of the family unit, it is the holding of the family unit that is relevant for the purpose of applying Section 4A and not the share of the individual in family unit. P. Venkat Reddy versus State of AP. Section 4A does not deal with the joint family properties or separate properties. Section 4A does not deal with joint family properties or separate properties as such. It deals with individuals and family units. A family unit may hold land comprising of separate or self-acquired properties or joint family properties. It may comprise of lands in which only one member of the family may have a right and the other members of the family unit may not have any right, or it may comprise of properties in which the several members of the family unit may have a joint right. But for the purpose of the ceiling Act, if they constitute members of one family unit, only their share therein has to be computed for ascertaining their holding under the Act. If such family unit holds less than the ceiling area to which is entitled, the holding of that parent would have to be increased over and above the ceiling area to which he is entitled to the extent of deficit of his major son, whether he be an individual or a member of the family unit. State of AP versus Tirupati Reddy or Madhav Reddy. Benefit of Section 4A is available only to persons who have major sons. On the commencement of the Act, the definition of a family unit does not include major sons, where an individual who is a member of family unit has one or more major sons. Any such major son, either himself or together with his family unit, holds an extent of land less than the ceiling area of the individual or of the family unit. The ceiling area has to be increased as laid down under Section 4A. And where his holdings fall short of the ceiling area, the deficit will be added to the land of the individual or of individual who is a member of the family. Where there is more than one major son, the extent by which the holding of each of his major sons falls short of the ceiling area would be added to the holding of the said individual. P. Chandrasekhar Reddy versus AP. Section 29A of the Hindu Succession Act does not confer any additional benefit to the unmarried daughters. While it is true that Section 29A of the Hindu Succession Act, the daughters acquire a right by birth as were deemed to be a co-partners of the joint family, and they have got a right to seek partition of the joint family property, but with regard to the fixation of the ceiling as the instant case, Section 29A was held not to confer any additional benefit to the appellant number 6 and 7 who are unmarried married daughters as on date. B. Chandrasekhar Reddy versus State of AP. A major son having excess land cannot refuse to surrender the excess land on the ground of deficiency on the holding of his mother. Where the High Court was applying the judgment of the division bench of PKR Raju's case, held that the declarant who the major son having excess land could not refuse to surrender excess land, that he could not be said to hold the same against deficiency in the holding of his mother. Supreme Court found no error in the judgment of the High Court. Kanchalla Madhusudan Rao versus State of AP. What do you understand by the terms dryland and wetland under the AP Telangana Land Reform Ceiling and Agriculture Holding Act? Meaning of wetland. 3.5 of the Act defines wetland in the following manner. Wetland means land registered as wet, single crop wet, compound double crop wet, or special rate wetland in the land revenue accounts of the government or assessed as such, and includes any land not registered as wet which has been included in the high cut of any government source of irrigation, irrigated by water from any government source of irrigation in any 4 firstly years within the continuous period of 6 firstly years immediately before the specified date, or irrigated by a tube well constructed by government or any person. Any land which has been registered as wetland in the land revenue accounts of the government on which no irrigated crop has been laid with the use of water from a government source of irrigation any 4 firstly years within a continuous period of 6 firstly years immediately before the specified date for want of supply of water from such source shall not be deemed to be a wetland. Judicial trends and case law. Wetland when amounts to the lands which are registered as dry lands in the revenue account of the government do not come under the definition of double crop wetland even if they are included in B schedule and registered as dry lands. Such land which are included under a government source of irrigation, they are to be treated as single crop wetland as per definition of the wetland. In the definition of double crop wetland under section 3D, when the term wetland is mentioned in the context of it, necessarily means that wetland as per registration in the revenue account. The legislature would not have intended by that expression wetland used in the definition as meaning also dry land by reason of inclusive provisions made under section 3.5 of the Act in the definition of wetland, as otherwise it will amount to placing the dry land 2 steps higher than its registration, which would not have intended the intention of the legislature. State of AP versus P. Lakshmanaran Reddy. Wetland when it does not amount to. In order to attract the definition of wetland, the land must be registered as wet in the first instance. When the lands are not registered wet, the definition of double crop has no application at all. In the present case, the lands were registered dry lands but localized for irrigation under the high cut of Nagarjuna Sagar project. Even though they were registered dry lands as per definition of the wetland given in section 3.5, they were held to be treated as wetlands since they were registered under a government source of irrigation. A. Pedda Muttaya versus State. When the land registered as dry but included in the high cut of Nagarjuna Sagar and no irrigated crop was raised from the water of the government source, such land was held not to be treated as wetland. K. Kotaya versus State of AP. Irrigable dry lands are not wetlands. A land which is registered in the revenue account as dry land and included in the high cut of a government source of irrigation as irrigable dry does not become wetland within the meaning of the Act. The lands which are registered merely as dry lands in the revenue accounts and localized as irrigated dry in the high cut of KC Canal cannot be deemed to be wetlands within the meaning of 351 of the Act. Lands which are registered as dry lands and included in the high cut of the government source of irrigation and irrigated dry do not fall within the ambit of section 351 and consequently explanation 6 to section 10 as well as section 17 have no application. B. Venkat Subba Reddy versus State of AP. Dry land cultivated by unauthorized use of the government water is not a wetland. The use of water from the government source noted in the proviso as well as irrigation by water from any government source of irrigated state in section 352 must be as of right. The user of government water by a landholder, either unauthorizedly, stealthily or with the permission of the concerned authorities on account of the drought of any special circumstances, any particular period would not anyway create a right in him to take water from the government source of irrigation as of right. The legislature would not have intended to include any dry land which has stealthily or unauthorizedly been cultivated by use of government water within the meaning of the wetland. The expression any land not registered as wet which has been irrigated by water from a government source of irrigation used in section 352 refers only to the land registered as dry though it is being irrigated from a government source of water. A. Mallareddy versus State of AP. Irrigable dry land cannot be treated as wetland. Any land which is dry or irrigable dry cannot be deemed or treated as wetland within the inclusive definition of section 351 A for theory, and such land cannot be included within explanation 6 to section 10 of the purpose of giving effect to section 17. By Venkat Reddy versus State of AP. Wetland when becomes continuously wet. It is quite manifest from the provisions enacted in the proviso of section 3.5 that any land which has been registered as wet to be continued to be as a wetland for the purpose of the Act, at least 4 irrigated crops should have been raised in the 6 firstly years immediately preceding the qualified date, a specified date. Therefore, the lands which are registered as wet in revenue accounts and on which 3 irrigated crops have not been raised within the continuous period of 6 firstly years immediately before the specified date have to be treated as dry lands within the meaning of section 3.5 of the Act. State of AP versus R. Sheshgir Rao. Private land should not be treated as government source of irrigation. Section 3.5 and H. Private land do not stand transferred to government on the abolition of the state under AP Mahal's abolition conversion to Raitwari regulation 1969. They cannot be treated as government sources of irrigation. K. Subbarao and others. Meaning of dry land. Section 3E of the Act defines the term dry land in the following manner. Dry land means land registered as dry, Manavari, Asmantari, Bhagat or garden land or special rate dry land in the land revenue accounts of the government are assessed as such and includes any other land excluding wetland. Judicial Trends and Case Law. As held by the High Court of Andhra Pradesh, K. Kotaya vs. State of AP, represented by District Collector, a land registered as dryland by including in the High Court of Nagarjuna Sagar, where no irrigated crop was raised from the water of the government source, could not be treated as a wetland. Defend the expression family unit under AP Telangana Reform Sealing and Agricultural Holding Act 1973. Section 3F of the Act defines family unit in the following manner. In the case of an individual who has a spouse or spouses, such individual, spouse and their minor sons and their unmarried minor daughters. In the case of an individual who has no spouse, such individual, his or her minor sons and unmarried minor daughters. In the case of an individual who is a divorced husband and who is not remarried, such individual and his minor sons and unmarried minor daughters, whether in his custody or not. When an individual and her spouse are both dead, their minor sons and unmarried minor daughters. Where a minor son is married, his wife and their offspring, if any, shall also be deemed to be members of the family unit of which the minor son is a member. While the statutory definition is as above, Indian judiciary has widened the scope of this term further by including within its meaning a minor co-partner, illegitimate minor children, and undivided minor sons. However, a co-widow, a second wife, and a child in the womb of the mother will not constitute a family unit, but are separate family units. The extent of property vested in an adopted son will be excluded from the family unit of his natural father or brother. The number of members in the family as existing on the notified date alone have to be considered for fixing the sealing area. Define the terms holding and standard holding under AP Telangana Land Reform Sealing and Agricultural Holding Act 1973. Section 3.1 of the Act defines the term holding to mean the entire land held by a person, whether as a full owner or as a limited owner, or as usufructuary mortgagee, or as a tenant, or as a person in possession of mortgage property by conditional sale, through a part performance of the contract for sale or otherwise, or any one or more of such capacities. While the above is the statutory definition of the term holding, Indian judiciary has extended the scope including the footpaths and lanes. However, lands put in possession of the transferee under a contract for sale, lands belonging to illatum son-in-law, separate property of wife, property existing in the name of second wife, lands validated under Section 50B of the Tenancy Act, lands covered by the valid sales, land in possession of tenant until reverted to the owner, lands granted to the protected tenants under the Andhra Pradesh Telangana Tenancy Agricultural Land Act do not form part of the holding. Section 3S of the above Act defines the term standard holding to mean the extent of land specified in Section 5 to be standard holding. Section 5 of the Act deals with the standard holdings for different classes of lands as set out in the first schedule to the Act. In case of wetland, it is classified as Class A to Class K, and each such classified land is again divided into double crop wetland and other than double crop wetland. The standard holdings are subject to other provisions provided in the Proviso 1 to 6 of Subsection 1 and the provisions of the Section 2 to 6 of Section 5. Indian judiciary has further widened the scope of the term standard holding. Accordingly, where two brothers are cultivating lands obtained on lease, standard holding should be treated as one. Similarly, where a partnership firm consists of 4 partners having equal share in the lands by purchase, the entire extent of land shall not be treated as one standard holding. In case of land with coconut garden, the extent of standard holding shall not exceed 10.93 hectares, and that is 27 acres. The share given to an illegitimate son-in-law in the father-in-law's property shall not be included in the standard holding of the father-in-law's property. Discuss the law relating to declaration of holdings under AP Telangana Land Reform Sealing and Agricultural Holding Act 1973. Every person whose holding in the notified date together with the lands transferred on or after 24 January 1971 in any manner should make a declaration of his holdings as required under Section 8 and shall be filed before the authorized officer tribunal within 30 days from the date of such notification. Such declaration should be in the prescribed form number 1. In case of a company, firm, association, other corporate bodies, declaration shall be furnished by an authorized person. In case of a family unit, declaration shall be filed by a person in the management of the property. According to the judicial trend, some lands cannot be declared by mother and son separately. Land under gift cannot be included in the declaration of holdings. Lands acquired under a court sale have to be excluded from declaration. If there is any dispute in the declaration, the tribunal shall decide the same after issuing notice to both the parties. Declaration of future acquisition. In respect of declaration of the future acquisition, the requirement under Section 18 discussed below shall be followed. Acquisition in any manner whatsoever, usufructuary, mortgage or lease of any land, marriage or adoption, alteration in the classification of the land. After such acquisition, if the total extent of the land held by the person or by all the members of the family unit and the aggregate exceeds the sealing area, then the declaration of such holding shall be furnished within a period of 60 days from the date of acquisition, usufructuary, mortgage, etc. in accordance with Section 8 of the Act, subject to the other provisions contemplated under Section 18 of the Act. The specified time limit for declaration of holding shall be, in case of a wetland, 4.05 hectares or 10 acres, and in the case of dry land, 10.2 hectares or 25 acres. 1 hectare of wetland shall be deemed to be equal to 2.5 hectares of dry land. The tribunal has to obtain the declaration within the specified time and publish the same after determining the ceiling area. A person who holds excess land is required to surrender the same to the government under Section 10. For this purpose, the tribunal has to serve a notice to file a statement indicating the particulars of the land required to be surrendered. Discuss the various provisions relating to refusal or acceptance or surrendered land under the Andhra Pradesh Telangana Land Reform Ceiling and Agricultural Holding Act 73. Under Section 10 of the Act, tribunal has the power either to accept or refuse surrendered land under the following cases. Land which has been converted into non-agricultural land and has been rendered incapable of being used for agriculture, a land surrender of which is not acceptable on account of a dispute as to the title of the land or an encumbrance on such land, on account of a land being in the possession of any person mentioned in Item 5, Clause 1, Section 3, that is, who is in possession by virtue of a mortgage, by conditional sale, or through part performance of a contract for sale of land, or otherwise, or in one or more such capacities, or on account of the land proposed to be surrendered becoming inaccessible by reason of its severance from the remaining part of the holding. In the above purpose, the tribunal should issue requisite notice. In case of surrendered land under mortgage, the tribunal can transfer such mortgage from the mortgaged land under surrender to any residuary holding of the mortgagor. In case of a surrender of land, the following procedures shall be followed. If there is any agreement between the members of the family unit, surrender shall be made according to such agreement. The extent of land to be surrendered by a female member of a family unit shall not exceed the extent to which she is liable to surrender in proportion to the total land held by her to lands held by all the family members. In case of a person who is a member of a cooperative society, company, or a firm, the surrendered land forms part of his share. Therein shall be presumed that his share is correspondingly reduced to the extent required for such surrender, and he may be required to surrender the land separately. All the land so surrendered shall vest in the government in accordance with the provisions of Section 11 and shall be allotted by the Tahsildar for use as house sites for agricultural labourers, village artisan, other houseless people, or to landless poor persons for agriculture or ancillary purpose as laid down in Section 14 of the Act. In case of a surrendered land in scheduled areas, the excess land should not be allotted or transferred by Tahsildar to persons other than members of the scheduled tribe. Discuss the extent of and procedure for allotment of lands under the Andhra Pradesh Telangana Land Reform Ceiling and Agricultural Holding Act 1973. The maximum extent of land which can be allotted to an individual or a family unit for house site shall not exceed 0.56 hectare 5 cents, and for agriculture or for ancillary purposes it shall not exceed 1.01 hectare 2.5 acres of wetland or 2.02 hectare 5 acres of dry land, subject to the specified condition under Sub-Rule 4, Rule 10 of 1974 rules as shown below. The allottee transferee shall pay to the government the sum specified under Section 14, Clause 2, a sum calculated at 15 times the land revenue payable on such land, subject to the maximum of 1250 per hectare in case of wetland, 375 per hectare in case of dry land. On payment of such amount, a patta shall be granted to such person in respect of that land, and such payment shall include the value of such trees or structures calculated in the prescribed manner in case of fruit-bearing trees, in 15 equal installments from the date of allotment or transfer of each annual installment being payable before the first day of March every year. Where the land transferred contains any fruit-bearing trees or permanent structures, the transferee shall also be liable to pay the value of such trees or structures as calculated as per Rule 11 and shall be recovered in 15 equal annual installments along with the sum payable for the land under Clause A. No installment of the sum payable shall be recovered in the first year in which the land revenue on the land is remitted or suspended, and such installment shall stand postponed by one first year, and the installment so postponed shall be recovered together with the installment of the succeeding year. The allottee or transferee shall, in accordance with the installment payable under this rule, be liable to pay the land revenue, other rates and taxes, if any, payable on the land. When land is allotted for use as a house site, the allottee shall utilize the same for construction of a house thereon within a period of 2 years from the date of allotment or such further period as Tahsildar may permit. Where the land is transferred for purpose of agriculture or for the purpose of ancillary thereto, land shall be cultivated personally by the transferee or any of the members of his family or by hard labour under supervision and control of himself and any member of his family. All lands allotted transferred shall be heritable but shall not be transferable except by way of mortgage in favour of the government, a bank, a cooperative society, including land mortgage bank. Discuss the various area of lands for which the Andhra Pradesh Telangana Land Reform Ceiling and Agricultural Holding Act does not apply. Section 23 of the Act provides the following areas of land which are exempt from applicability of the above Act: lands held by the state or central government or any local authority, lands held by religious, charitable, educational institution, including a waqf of a public nature existing on the date of commencement of this Act, added as per Act 9 of 1974, Section 3. Lands held by an undertaking owned, controlled or managed by a government company as defined in Section 617 of Companies Act, corporation established by or under central, provincial, state act, controlled, managed by state or central government, lands covered by tea, coffee, cocoa, cardamom or rubber plantations, lands held by such cooperative farming societies of weaker sections as may be approved by the government in this behalf, which approval the government may for good and sufficient reason withdraw at any time. Other cooperative societies including land mortgage banks, lands held by a bank, lands vested in AP, Bhudan Yajna Board or a Gram Sabha, lands in any area notified by the government in this behalf as required for acquisition in connection with any major irrigation, power, industrial, other project under construction as on the date of commencement of this Act. Above exemptions are subject to the following conditions and limitations. Where any of the lands specified in clauses 1, 2, 3, 4, 5, 6, 7 are held by any person other than the authority, institution, body, corporate, society specified in such clause, whether such as a tenant or a supervisory mortgagee or otherwise, the provisions of this Act shall apply to such person in respect of such land. Exemptions under Section B, Item B of Class 4 and Class 6 mentioned above shall be available only in respect of lands acquired by such cooperative societies or banks in pursuance of the recovery of their dues. Exemption under A of Class 3 mentioned above shall be available only in respect of such part of the land as may be relatable to the share held by state or central government in the respective government company, and for this purpose the share of the land so relatable shall be deemed to be the extent of land which would have been allotted to the said government on winding up of the company. Discuss the legal provisions relating to the constitutional powers and functions of the tribunals under AP Telangana Land Reform Sealing and Agriculture Holding Act 1973. Constitution of Tribunals. Section 6 of the Act empowers the state government by notification to constitute as many tribunals as may be necessary for the purpose of to act specifying the jurisdiction of each such tribunal. Composition of Tribunal. Subsection 2 of Section 6 contemplates that each tribunal shall consist of not more than 3 members. One such member should be a person who holds or has been a civil post under the state not below the rank of a deputy collector, or a person who holds or has held or is qualified to hold the post of a district municipal, and such person shall be the chairman of the tribunal. Reconstitution of Tribunals. Section 6 Clause 3 of the Act empowers the government to reconstitute a tribunal from time to time or abolish a tribunal at any point of time. Quorum. As provided for in Section 6.4 and 6.5 of the Act, the quorum to constitute a meeting of the tribunal and the procedure to be followed by it shall be such as may be prescribed, and that no act or proceeding of such tribunal shall be deemed to be invalid by reason of existence of any vacancy among its members or any defect in the constitution or reconstitution thereof. Powers and functions. The power and functions of the tribunal are spread over in various sections of the Act. Act provides ample powers on the tribunals. While the legal powers as above, Indian judiciary has widened the scope of the powers and functions of tribunals in the following manner. A tribunal under the Act is a court and not a persona designata. A tribunal cannot reopen an inquiry on the direction of the Commissioner of Land Reforms. A tribunal has discretion to accept or refuse surrender of a disputed land. A tribunal may make any local inspection. A tribunal can accept surrender of encumbered land. A tribunal can review its own order. Discuss the constitution, powers and functions of the appellate tribunals under the Andhra Pradesh Telangana Land Reform Sealing Agricultural Land Holding Act 1973. Constitution. Section 20 of the Act empowers the government to constitute as many appellate tribunals as are necessary for the purpose of the Act by notification specifying therein the jurisdiction of each such appellate tribunal. Each appellate tribunal constituted shall consist of not more than 3 members, of whom one shall be a person who holds or has held a civil post under the state not below the rank of district revenue officer, or a person who holds or has held or is qualified to hold the post of a district judge. Such person shall be chairman of the tribunal. An appeal shall lie against an order passed by the tribunal or revenue division officer to the appellate tribunal within 30 days of the date of communication of the order. The appellate tribunal shall pass such order on the appeal as it deems fit, and such order shall be final subject to revision of Section 21 of the Act. The provisions of subsection 3, 4 and 5 of the Section 6 shall apply in relation to the appellate tribunal as they apply in relation to a tribunal with the substitution of references to the appellate tribunal for references to the tribunal. Where the government are aggrieved by an order passed by the tribunal or RDO, they may file an appeal to the appellate tribunal against that order. Powers and functions. Powers and functions of the appellate tribunal are envisaged inter alia in Section 22 of the Act. In fact, Section 22 has a common section which provides for powers of all authorities under the Act, namely the appellate tribunal, RDO, any officer authorized by the tribunal, RDO, to exercise any powers under the Act. These authorities thus shall have the same powers as vested in the civil court under CPC 1908 for summoning and enforcing the attendance of any person, examining him on oath, and for requiring production of any document. Appellate tribunal and other above named authorities may enter upon any land at any time, but not a dwelling house, with such other officer or persons as it or he considers necessary, and make a survey and take measurements thereof, or do any other act which it or he considers necessary for carrying out any of the provisions of the Act. Section 21 of the Act provides revisional power on High Court of the state as against the order passed by the appellate tribunal on the grounds specified therein. Land assignment and prohibition of alienation or transfer. Trace out the historical background for the enactment of Andhra Pradesh Telangana Assigned Lands Prohibition of Transfer Act 1977. Subject matter of the assignment of land is one of the important measures in the field of land reforms, attracting inter alia the provisions of Part 4 DPSP under Constitution. The government or erstwhile common state of Andhra Pradesh before its bifurcation into two states of AP and Telangana launched a special crash program for assignment of government wasteland to landless poor with effect from 1st November 1969. Lands assigned under that scheme were prohibited from alienation. However, it was observed that substantial extent of lands assigned to the landless poor were virtually alienated too and possessed by well-to-do persons. With a view to curb this unexpected, unwelcome development, the AP Assigned Land Prohibition of Transfer Act was enacted as early as in 1977, which prohibits alienation of assigned lands and provides for punishment on purchases of such lands. Another milestone in the direction of the prohibition of the transfer of land in the then state of Andhra Pradesh was the AP Scheduled Area Land Transfer Regulation 1959. This regulation was aimed at protecting tribal lands and agency tracts from transfer to non-tribal. This regulation has also been adopted by the state of Telangana on the formation of 2/6/2014, changing its title as Telangana Scheduled Area Land Transfer Regulation 1959. After reorganization of the erstwhile state of Andhra Pradesh, the present act has been adopted by the government of both the states and continued its operation in their respective states with effect from 2/6/2014 while AP Reorganization Act 2014. However, in case of Telangana, said act has been renamed as Telangana Assigned Land Prohibition of Transfer Act 77. After bifurcation, respective states have made their own amendments wherever possible by suiting their needs. Accordingly, newly formed state of Andhra Pradesh, by Amendment 11 of 2019, which has come into force on 29 January 2019, has amended Section 2(1) of the Principal Act by substituting incorporating words lands or house sites assigned, replacing the existing words lands assigned, and landless or homeless poor persons, replacing the then existing words landless poor persons wherever they occur. By the said Amendment Act, Section 3 of the Principal Act has also been amended by inserting 3 subsections of 2A, 2B, 2C after subsection 2, apart from inserting the expression or subsection 2A after existing subsections 2. Similarly, newly formed state of Telangana also made amendment to Section 4 of the Principal Act by substituting incorporating words on or before 31/12/2017 in place of words on or before 29/1/2007. By the Telangana Amendment Act 2018 so as to come into force in 2018 March. By this Amendment Act, the name of the Principal Act has also been renamed as Telangana Assigned Land Prohibition of Transfer Act 1977 so as to come into force from the said date of 5/3/2018. That means Principal Act of 1977 has been in force in the newly formed state of Telangana with its original name for the period of 2014 to 2018. In view of the foregoing factual matrix, it can safely be mentioned that the law relating to assignment of land in respect of both newly formed states is the same and similar as that of the law prevailing prior to the formation of the states except to the extent of amendment discussed above. Therefore, for the present purpose, the law relating thereto is discussed conjointly in respect of both the states, so that the repetition of the same provisions can be avoided. This chapter deals with the above aspects of law contained in Act 77 as prevailing in the said states of Andhra Pradesh and Telangana commonly as a whole. Discuss precisely salient features of the AP Telangana Assigned Land Prohibition of Transfer Act 77. Following are some of the important salient features of the Act. The Act, which has to be deemed to have come into force with effect from 21st January 77 by repealing the then existing Ordinance 77, contains only 12 sections, running in sequence without there being any chapters. The objective of this Act is to prohibit transfer of certain lands assigned to landless or homeless poor persons in the state of Andhra Pradesh, landless and poor persons in the state of Telangana as envisaged in the preambles of the respective Acts. Section 2 of the Act provides for definitions in various terms used in the Act such as assigned land, government, landless poor person in case of Telangana, and landless or homeless poor person in case of Andhra Pradesh, notification, prescribed and transfer. While Section 3 of the Act prohibits transfer of assigned land, Section 4 thereof empowers the district collector, any of his authorized officer not below the rank of MRO, to take possession of the assigned land and restore the same to the original assignee or his legal heirs, or to resume the assigned land to the government for assignment to landless poor, as the case may be, in case where the land is transferred under Section 3. Section 4A of the Act provides provision for appeal by any aggrieved person against an order passed by the MRO within prescribed time to the RDO. Similarly, Section 4B of the Act provides for revisional powers on the part of the district collector, either suo motu or on an application made to him, as to the regularity of any proceedings, not being an appeal made by an aggrieved person against the order passed by RDO under Section 4A1 of the Act. Section 5 of the Act prohibits registration of documents relating to transfer of any assigned lands or documents creating any interest therein. Section 6 of the Act exempts applicability of the Act to the assigned lands held on mortgage by the state or central government, any local authority or a cooperative society, a scheduled bank, or any other financial institution owned, controlled, or managed by state or central government. Section 7 of the Act provides for penal provision in respect of persons who acquire any assigned lands in contravention of the provisions of Section 3, Clause 2 of the Act, with the punishment of imprisonment which may extend to 6 months or with fine which may extend to 2,000 or both. Similarly, the section also provides for punishment on those who oppose or impede the district collector or any person authorized in taking possession of any assigned land with imprisonment which may extend to 6 months with a fine extend to 5,000 or both. Under the Act, no court shall take cognizance of an offence punishable under Section 7 except with the previous sanction of the district collector. Section 8 of the Act provides provision for protecting the action taken by any person, officer, authority for anything done in good faith or intended to be done in pursuance of the Act, any rules made thereunder against any suit, prosecution, or other legal proceedings. Such protection is extended to the government for any damage caused or likely to be caused, for any injury suffered or likely to be suffered by any person by virtue of any of the provisions of the Act, or for any act done in good faith or intended to be done in pursuance of the Act or any rules made thereunder. Section 9 of the Act empowers the state government to make rules by notification for carrying out all or any of the purposes of the Act, which shall also require laying before each house of the state legislature immediately after the same is so made. Accordingly, the respective states have adopted the then existing rules of 2007, presumably with the above mentioned change, with the title AP Telangana Assigned Land Prohibition Transfer Rules 2007. Section 10 of the Act provides for the overriding effect of the Act or over the other laws for the time being in force, or over any custom, usage, or contract or decree or other of the court, tribunal, or authority. Section 11 of the Act empowers the state government to remove difficulties in giving effect to the provisions of the Act by a general or a special order published in the State Gazette. What do you understand by the terms assigned land or alienation of land under AP Telangana Assigned Land Prohibition of Transfer Act 77? Meaning of assigned land. In case of state of AP, the term assigned land as defined in Section 21 of the AP Act means land or houses sites assigned by the government to the landless or homeless poor persons under rules for the time being in force, subject to the condition of non-alienation, includes lands allotted transferred to the landless, homeless, poor persons under relevant law for the time being in force relating to land ceiling. The word assigned shall be construed accordingly. That means lands assigned must not be alienated. In case of state of Telangana, under Telangana Act, the above term 2.1 to denote lands assigned by government to the landless poor person under rules in force subject to the condition of non-alienation includes lands allotted or transferred to the landless poor person under relevant law in force. Relating to land ceiling, in the words assigned land shall be construed accordingly. Meaning of alienation. Both AP and Telangana do not define the term alienation. Alienation in general connotation means transfer of immovable property by way of sale, gift, exchange, mortgage, lease, or any other mode. However, Section 2(6) of the both acts define transfer in the following words. Transfer means any sale, gift, exchange, mortgage with or without possession, lease, or any other transaction with assigned lands not being a testamentary disposition, and includes a charge on such property or a contract relating to assigned lands in respect of such sale, gift, exchange, mortgage, lease, or other transaction. However, as provided for in the explanation below, subsection 1, section 2 envisages a mortgage in favour of the following shall not be regarded as alienation, namely the central government or the state government or any local authority, any cooperative society registered or deemed to be registered under AP State Cooperative Societies Act, any bank which includes the following banks, namely Agricultural Development Bank, Reserve Bank of India, State Bank of India, subsidiary bank of State Bank of India, corresponding new bank constituted under Banking Companies Acquisition Act. Right, short notes on landless, homeless, poor person and landless poor person. Landless or homeless poor person. Section 2(3) of the AP Act defines the term as landless or homeless poor person by substituting the word landless poor person via amendment of 2019. Landless poor person. Section 2(3) of the Telangana Act defines the landless poor person. Accordingly, a landless or homeless poor person in the state of AP as well as a landless poor person in the state of Telangana is a person who owns an extent of land not more than 1.011715 hectares, 2.5 acres, or a wetland, or 2.023430 hectares, 5 acres of the land, and such other extent of land as has been specified by the government in this behalf. From time to time, and who has no other means of livelihood. That means a person to be considered as landless poor person in Telangana state and landless or homeless poor person in AP state for the purpose of assignment of land should be one who owns the land to the extent prescribed under section 2(3) and that he should not have any other means of livelihood except that land. Explain in brief the various legal measures provided for the prohibition of the transfer of assigned land under AP Telangana Assigned Land Prohibition of Transfer Act. Section 3 of the both acts prohibit transfer of assigned lands, including alienation of land made before or after coming into force of the respective acts uniformly. However, in respect of the state of AP, Section 3 of the Act has been amended incorporating a new subsection, that is 2A, 2B, 2C. But the AP Amendment Act 2019, which shall be deemed to have come into force with effect from on or from 29 January 2019, according to which no assignee shall transfer any assigned land, house site, and no person shall acquire any assigned house site either by purchase, gift, lease, mortgage, exchange, or otherwise, till completion of the period of 20 years from the date of assignment, and where the assigned house site was alienated in the date of commencement of this act, such house site shall be regularized in favor of the alienee as a one-time measure, and also the eligible family shall be assigned house site only once in lifetime. Following are the essential requirements of attracting the prohibitory provisions of Section 3 of both the Acts in respect of assigned land. Land must have been assigned by the government to a landless poor. Assignment of land must be for cultivation or a house site. Assigned land shall not be transferred and shall be deemed never to have been transferred, notwithstanding anything in the contrary in any other law for time being enforced, or in the deed to transfer or other document relating to such land, except in case of testamentary succession of Section 2, Clause 6. No right or title in such assigned land shall vest in any person acquired by the land by such transfer. No landless poor person shall transfer any assigned land. No person shall acquire any assigned land either by purchase, gift, lease, mortgage, exchange, or otherwise, except the following cases. Testamentary succession in terms of 2 Clause 6. Purchase of assigned land by landless poor person in good faith and for valuable consideration from the original assignee or his transferee prior to the commencement of the act, which is in possession of such person for purpose of cultivation, or as a house site on the date of commencement of the act, Section 3, Clause 5. And prohibition under Section 3 shall apply to any transaction of the nature referred to in the execution of a decree or order of a civil court or any award or order of any other authority. Trace out the consequences of transferring of the assigned land under the AP Telangana Assigned Land Prohibition of Transfer Act. Section 4 and 5 of the Act provide for the following consequences of transferring assigned land in contravention of the Section 3 Clause 1, namely, under Section 4, District Collector, any authorized officer not below the rank of MRO or Tahsildar, having satisfied that the provisions of Section 3(1) have been contravened, he may order take possession of the assigned land after evicting the person in possession of such land in prescribed manner, restore the assigned land to the original assignee or his legal heir. Where it is not reasonably practicable to restore land to such assignee or legal heir, resume the land to the government for assignment to landless poor persons in accordance with the rules enforced. Assigned land shall not be restored to the original assignee or his legal heir more than once. Where the original assignee or his legal heir transfers the assigned land again after such restoration, it shall be resumed to the government for assignment to any other landless poor person. Any order passed in revision of the Section 4B or the Section Appeal of 4A, any order passed under Section 4(1) either by District Collector or authorized officer shall be final, shall not be questioned in any court of law as per 4(2). No injunction shall be granted by any court in respect of any proceeding taken or about to be taken by any officer or authority or government in pursuance of any power conferred by or under the Act, Section 4(2). Where any assigned land is in possession of a person other than the original assignee or legal heir, it will be presumed that there is a contravention of the provisions of Section 3(1) until the contrary is proved. Section 5. No registering officer shall accept for registration any document relating to the transfer or the creation of any interest in the assigned land, including a list of assigned lands in the district prepared by the district collector and furnished to the registering officer, except after obtaining prior permission of the district collector consent for such registration. This requirement is the sine qua non, notwithstanding anything contained in Registration Act 1908. Section 6 of both AP Telangana Acts provide for exemption from applicability of the Act in the following cases. Assigned lands held on mortgage by state or central government, by local authority, by cooperative society, by scheduled bank, by such other financial institution owned, controlled or managed by the state or central government. Regulation of alienation of land in scheduled tribal areas. Trace out the historical background for regulation of the alienation of land in the scheduled areas in India. 90% of the scheduled tribes predominantly live in forest areas and intractable terrains. 95% of them were below poverty line, totally dependent on agriculture and agriculture-based activities. Some of them eked out their living in a migrant construction labor on their displacement from their hearth and home. For the so-called exploitation of minerals and construction of projects in the past few centuries, tribals have gradually been pushed back into forests and hills by non-tribal settlers. The forest and hills provide a natural barrier and isolated tribals from people living in the plains. Living in isolation, they developed their own society and allowed themselves to be governed by their own customary laws and rituals. These tribes hitherto adopted traditional shifting of cultivation, Podu or Jhum, predominantly prevalent in Andhra Pradesh. Due to pressure on the land, shifting cultivation was abandoned and the tribes started settling down to cultivate crops in fixed holdings. Samata versus State of AP. B. Shivarao, Study Volume 5 on the Framing of Indian Constitution. Prior to 1874, such enactments were made for the administration of justice and collection of revenue in agency areas. As doubts arose as to which act or regulation were enforced in different parts of British India, Scheduled District Act 14 of 1874 came to be passed. The said act defined the term scheduled district to mean territories mentioned in the first schedule annexed thereto, and to also include any other territory to which the Secretary of State for India by resolution in council may declare. The Scheduled District Act specified a number of tracts and scheduled tracts, and the power was given to the local government to declare by notification what enactments were not enforced to any scheduled area or scheduled district, to provide for extending by notification to any scheduled district with or without modification or restriction or enactment of force in any part of the British India. The first schedule of the said act listed several tracts in the various states of British India Insofar as the erstwhile composite of state of Madras was concerned, scheduled district comprised certain agency tracts in Visakhapatnam, Godavari district. By subsequent notification, the act was extended to Bhadrachalam Taluk. Agency rules were made in excess of the powers conferred under Section 6 of the Scheduled District Act 1874 for administration of the agency tract and to regulate the procedure for officers so appointed to administer them. Under Rule 1 thereof, the collector, district magistrate and designation agent to state government are to be the collectors, district magistrate, district judges within the agency tracts included in their respective district. Rule 1 Clause 2 vested in the agent same power as vested in the revenue courts for trial and determination of the suit coming before them. The agency rules contain separate provisions for civil justice, jurisdiction of courts, transfer of suit for institution, trial and determination of suits. Subsequently, the Agency Tax Interest and Land Transfer Act 1917 came to be passed with the object of limiting the rate of interest and to check the transfer of lands in agency tracts. Vemana Sornalamma includes lands in Ganjam, Visakhapatnam, Godavari areas. These areas were described as agency tract and they were under administration of the agent. Section 2A Act 1917 defined agency tract to mean the scheduled district as defined in Scheduled District Act 1874. Hota Venkateswari Sivarama Shastri versus Andhra Pradesh, G. Venkateswara versus District Collector, Khammam. In the 92-1 Government of India Act 1935 excluded from an excluded or partially excluded area all legislation and no act was operative within such area unless a notification to that effect was published by the governor of the province in the manner indicated therein. The provisions of Section 92-1 similar to those contained to Section 5 and 5A of the Scheduled District Act, though in the earlier act the sanction of the Governor General and Council was necessary even for making a notification. Yachendranath Gupta versus Province of Bihar. No act of the federal legislature or of the provincial legislature was to apply to an excluded or a partially excluded area unless the governor by public notification so directed. Section 92 Clause 2 of the Government of India Act 1935 conferred power on the governor to make regulation for the peace and good government of any area in the province which was an excluded or a partially excluded area, and any regulation so made could repeal or amend any act of the federal legislature or provincial legislature or any existing Indian law which was for the time being applicable to the area in question. Ram Kirpal Bhagat versus State of Bihar. The powers exercised by a governor under Section 92 Clause 2 of the Government of India Act was legislative powers. The governor was expressly empowered to repeal or amend any act of the federal legislature or of provincial legislature or any extant law which he considered necessary in the interest of peace and good government. The exercise of this power was not limited to any period of time or to any particular entry in the three lists in the 7th schedule to the Act. With regard to the excluded or partially excluded areas with a substantial element of aboriginal population, the policy was to make the general rules of law and procedure obtaining in other parts of the country inapplicable to them and to vest authority in the Governor General and Council or the administrative head of the province to legislate for them in summary manner. Jitendranath Gupta. Subsequently, by the Government of India, adoption of Indian Laws Order 1937, the Scheduled Districts Act 1874 was repealed. Then excluded, partially excluded areas came directly under governance of the governor under Section 92 of the Government of India Act 1935. The information discussed in the above paragraphs is the recorded version of the learned single judge of High Court of the then Andhra Pradesh in the case cited, Mandara Ramakrishna versus State of Andhra Pradesh and 8 others. Petition numbers of 2011-2013 debated in 2014. Trace out the historical background for the regulation of land in the scheduled areas along with salient features of the AP Telangana Scheduled Area Land Transfer Regulation 1959. Historical sketch. With a view to regulate the transfer of land in the scheduled areas of East Godavari, West Godavari, Visakhapatnam, Srikakulam, then and now fall under the state of Andhra Pradesh, and Adilabad, Warangal, Khammam and Mahabubnagar district now fall under the state of Telangana. The then prevailing Andhra Pradesh Scheduled Area Land Transfer Regulation was enacted in the year 1950. In fact, in the scheduled area of Andhra Pradesh and Telangana, land was entirely in the occupation of different tribal communities. It was not an accessible tract of land and was covered by forests and hills. The livelihood of tribal communities was based on cultivation and other natural resources available in such areas. They adopted the method of shifting cultivation undertaken for a year or two, and that area was abandoned. The area covered by the vegetation was burnt to use as manure. Thereafter, another area was cleared, cultivated, and again abandoned. That means when vegetation was regenerated in the abandoned area, it was again cleared and burnt. In view of the various protective legislative measures, the shifting cultivation method has now been abandoned and the tribes are settling to cultivate crops in fixed holdings. In fact, this was the position in respect of almost all the tribal areas. The above mentioned regulation was one of such legislative measures aimed at protecting the tribal area lands and the livelihood of tribals. On the bifurcation of the erstwhile combined state of Andhra Pradesh, With effect from 26/2014, the said Act has been adopted by both the newly formed states of the Andhra Pradesh and Telangana and continuing its operation till date. However, in case of state of Telangana, the said regulation has been renamed as Telangana Scheduled Area Land Transfer Regulation 1959. Therefore, the said regulation, as in force in both the states discussed below conjointly, since both the statutes contain same and similar provisions. Salient features of the regulation of AP and Telangana. Following are some of the important salient features of the regulation 1959 prevailing in the state of AP Telangana. Section 2 of the regulation of both the states provides for definition in various important terms like agency, tract, agent, divisional officer, immovable property, scheduled tribe, transfer. Section 3, 3A, 3B of both regulations provide provision for transfer of immovable property by a member of a scheduled tribe, special provision in respect of mortgages without possession and restriction on the registration. Section 4 of both the regulations deal with the suits against a member of scheduled tribe to be instituted in the agency courts, notwithstanding anything contained in any enactment, rule or law in force in the agency tract. Section 5 of both the regulation envisages no immovable property in the agency tract owned by a member of ST shall be liable to be attached and sold in execution. As provided for in Section 6 of both the regulation, state government has revisional power over any decree or order passed by an agent, agency, or divisional officer and any other prescribed officer under regulation, while Section 6B of both the regulations provide that all the offences under the regulation are cognizable, notwithstanding anything in the Code of Criminal Procedure 1898, Section 68 thereof provides for various penalties for acquiring any immovable property in contravention of the provisions of the regulations or continues in possession thereof after a decree of ejectment is passed in the form of imprisonment or fine or both. Section 7 of both the regulations make the Provision of Limitation Act applicable to the proceedings under this regulation. Section 8 of both the regulations empower the state government to make rules to carry out the purposes of the regulation. Section 9 of both the regulations repeal the Agency Tract Interest in Land Transfer Act 1917 to the extent to which any of the provisions contained therein correspond or are repugnant to any of the provisions of this regulation. Section 10 of both the regulations provide for saving clauses. Next. What do you understand by the following terms appearing under the AP Telangana Scheduled Area Land Transfer Regulation? Agency Tract, Agent, Immovable Property, Scheduled Tribe and Transfer. Agency Tract. As provided in Section 2A of both the regulations, Agency Tract means areas in the district of East Godavari, West Godavari, Visakhapatnam, Srikakulam in AP, Adilabad, Warangal, Khammam, Mahbubnagar in Telangana, declared from time to time in scheduled area by the President under subparagraph 6.1 of the 5th Schedule of the Constitution. Agent. Agent means the person designated by the state government as agent to the government in the district of East Godavari, West Godavari, Visakhapatnam, Srikakulam, Adilabad, Warangal, Khammam, Mahbubnagar as the case may be, as provided under Section 2B. Immovable property. As provided for in Section 2D of both regulations, immovable property includes standing crops, timber and trees but does not include growing grass. Scheduled tribe. As defined in 2F of both regulations, scheduled tribe means any tribe or tribal community or part or a group within a tribe or tribal community and specified as such in relation to the state of AP Telangana by public notification by the President under Clause 1, Article 342 of the Constitution. Transfer. Section 2G of both the regulations defines the term transfer to mean mortgage with or without possession, lease, sale, gift, exchange, any other dealing with the immovable property not being a testamentary disposition. Also a charge on such property and a contract relating to such property in respect of such mortgage, lease, sale, gift, exchange or other dealing. Discuss the provisions relating to transfer of immovable property by a member of scheduled tribe under the AP Telangana Scheduled Area Land Transfer Regulation 1959 as provided for in Section 3 of both the regulations. Any transfer of immovable property situated in the agency tract belonging to a member of ST shall be absolutely null and void unless such transfer is made in favor of a person who is a member of ST or a society registered or deemed to be registered under AP Telangana Cooperative Societies Act, which is composed solely of members of STs. Until the contrary is proved, any immovable property situated in agency tract and in possession of a person who is not a member of ST, it shall be presumed to have been acquired by a person or his predecessor in possession through a transfer made to him by a member of ST, where any person intends to sell his land but is not able to effect such a sale by reason of the fact that no member of ST is willing to purchase the land on the terms offered by such person, then such person may apply to the agent, agency, divisional officer or any other prescribed officer for the acquisition of such land by the state government. Then the agent, agency, divisional officer, prescribed officer as the case may be by order take over such land by paying compensation in accordance with the principles laid down in Section 10 of the AP Telangana Sealing and Agricultural Holding Act. Such land shall thereupon vest in the state government shall be disposed of in favour of members of ST or a society registered or deemed to have registered under AP Telangana Cooperative Societies Act 1964, composed solely of members of the scheduled tribe or in such other manner and subject to such conditions as may be prescribed. Validity of transfer of property by mortgage. As provided for Section 3B of both the regulations, notwithstanding anything contained in Registration Act 1908, no document relating to transfer of immovable property situated in the agency tract shall be registered by any registering officer appointed under the said Act unless the person presenting the document furnishes declaration by the transferee in the prescribed form, which shall be subject to verification in the prescribed manner, that the transferee is a member of ST or a society registered or deemed to be registered under the AP Telangana Cooperative Societies Act, which is composed solely of members of STs. Restoration of property transferred in contravention of Section 3.1 of the Act. Where a transfer of property is made in contravention of the provisions of Section 3.1 of the aforementioned agent, the agency divisional officer or any other prescribed officer may either suo motu or an application made by anyone interested or an information given to him in writing by a public servant decree ejectment against any person in possession of such property, after giving due notice to him in the prescribed manner, and restore the property to the transferor or his heirs. If the transferor or his heirs are not willing to take back the property or where their whereabouts are not known, then the agency divisional officer and the prescribed officer, as the case may be, may order the assignment of the sale of property to any other member of the ST or a society registered or deemed to be registered under any law resulting to cooperative societies for the time being in force in the state comprised solely members of ST. Otherwise, dispose of it was as if it was the property at the disposal of the state government. Suits against a member of scheduled tribe have to be instituted in the agency courts. A suit against a member of a scheduled tribe shall be instituted only in a court having jurisdiction over the agency tract, notwithstanding anything contained in enactment, rule or law in force in the agency tracts as provided for under Section 4.